My name is John P.L.C. I'm a probate litigator in Florida. I'm with the West Palm Beach Law Office of the P.L.C. Law Firm. We handle disputes, mediations, and trials involving wills, trusts, and estates, guardianship matters, and related business and commercial litigation, real estate, contracts, insurance, and bank accounts. Today is April 20th, 2016, and I'm going to be speaking to you about a probate litigation topic today, namely who may be appointed the personal representative of one's estate in Florida and who may be disqualified. Specifically, you can look at the estate of Sharonda Renee Butler that was just handed down by Palm Beach's 4th District Court of Appeal. The 4th DCA renders appellate opinions on probate, trust, and guardianship matters for Broward County, Fort Lauderdale, Palm Beach County, and Martin County. And this particular case, the appellate number is 4D, 4th District 15, a 2015 case, 1912. This was an appeal from Judge Mark Gold's ruling down in Fort Lauderdale, and Judge Gold was affirmed on appeal. And Judge Gold denied the sole heir of a deceased woman the ability to be the personal representative of the decedent's estate, and the reason for that was that he was convicted of a felony. In Florida, you cannot be the personal representative or executor of one's estate if you are a felon. If you're a convicted felon, you cannot be in charge of one's estate in Florida, and that's statutory, right? You can read the Florida Probate Code 733.303 1A. Persons not qualified to be the personal representative of a Florida estate, somebody who's been convicted of a felony. Now, many probate lawyers in Florida know this, right? They know that there are certain persons who are disqualified per se from serving. That's different than being permitted to serve, being fit to serve, or being competent to serve. And if you want, you can read the Florida Probate Code and look for different preferences that the law has of who may have a leg up on running a Florida probate or Florida estate. So 733.301 in the Florida Probate Code discusses who has preference in an appointment to be a personal representative. And then 733.302 discusses who may be appointed personal representative. And then there's other provisions that speak to non-blood relatives, people who are not related to the decedent through family, non-residents of Florida, and they speak to trust companies and other corporations and whether they may serve as personal representative of one's estate. So many probate attorneys, probate lawyers in Florida understand this. It appears unfortunate that this had to be the subject of an estate litigation lawsuit in Fort Lauderdale because it was a clear statutory interpretation that was correct, and the 4th DCA affirmed it in a very short, looks like a 4-sentence opinion. That concludes my remarks about this Florida estate litigation topic.